Welcome. I'm David Nispel, the General Counsel for the Wisconsin Department of Employee Trust Funds. Today I will talk with you about ethics and fiduciary duty. This presentation is designed for new board members, and it involves the Wisconsin retirement system. The PowerPoint slides that are shown in this presentation are also available in a PDF document. Chapter 40 is the beginning point for our discussion about fiduciary duty and for the Wisconsin retirement system. The WRS is governed by Chapter 40. Board members should become familiar with Chapter 40 generally and their specific responsibilities that appear in Chapter 40 for each of the boards attached to the department. Chapter 40 is available online at the ETF website, and you can also access it by clicking on links on this webcast at the bottom of the viewer. So who is a WRS fiduciary? Generally speaking, it is someone who holds assets in trust or confidence for a beneficiary. With respect to the WRS, it is someone who holds discretionary authority for the trust plan and the assets of the system. Board membership includes fiduciary responsibility to protect the trust fund and to assure funding for future retirement benefits. And one of the principles that I hope you take away from this presentation is that as a WRS board member, you represent all participants of the WRS, not just any particular association or subgroup of which you may be a member. The next two slides refer to several fiduciary duties that you have as a board member. I'm only going to highlight several of those on each of the two slides. One duty is to ensure that the WRS receives all the funds to which it is entitled. Another is to make good to the pension plan for any losses from breaching a fiduciary responsibility. Fiduciaries are personally reliable for any breach. A third responsibility is to comply with all of the applicable plan documents. And finally, to comply with all laws and regulations that pertain to the WRS. One of the most understood or commonly understood duties of a fiduciary is to inform members. But also people misunderstand that duty to mean that they should give advice to members. That is not the case. Please remember that you should inform the members as you think it's necessary about any item that comes before you as a board member, such as at a board meeting, but it is not a duty of yours to give advice to any member or participant of the system. You should act solely in the member's interest for the purpose of providing benefits to the participants and to the beneficiaries. And you should act prudently when carrying out your specific responsibilities. A person's fiduciary duty is limited to the scope of the responsibility that he or she assumes. So how does one become a fiduciary? There are three common ways that can occur. One is by accepting a position on a board, such as yourself. Another is by assuming certain responsibilities, even if it is not required by the statutes. And a third method is by agreeing to fiduciary standards that are set forth in a contract. So who are fiduciaries? All board members, some advisors, such as actuaries, those individuals who have discretion over benefit eligibility, and some internal ETF staff. The next two slides refer to resources that are available to you as a board member and identifying fiduciary standards. I encourage you to look at each of those slides on your own time. I'm not going to discuss those during the course of this presentation. Exercising prudence as a board member. If trustees are not experts, they are expected to carefully hire, monitor, and evaluate the experts that they do rely on. And please remember that experts exist inside and outside of the organization, specifically in the Employee Trust Funds Department. Questioning experts is not impolite, In fact, you're encouraged as a fiduciary to ask questions of those experts. Trustees must do the right thing while incurring only reasonable expenses. And what is meant by reasonable? Essentially, it comes down to common sense, to incurring only those expenses that are directly related to performing your duties and to using sound judgment as a board member. Public retirement systems may be challenged about expenses by the press, and they sometimes are by members of the public, but usually not by the courts. Delegating and interpretation of prudence. As concerns delegation, it is allowed for you to delegate your responsibilities from time to time, but not to abdicate those responsibilities. You should carefully select those individuals who work for you, and you should monitor them on a regular basis. Trustees are protected if they act prudently when delegating their duties. As concerns interpretation of prudence, use current standards, not outdated ones. Consider what is going on nationwide with other public retirement systems. And please always remember to try to follow the very best practices that pertain to your service as a board member. The next two slides refer to practicing and verifying prudence. And again, I'm not going to refer to the specific information that appears on those slides, other than to note that they refer to prudence in benefit administration and in operations, and that there's a benefit standard, or a prudence standard rather, that appears in the slides. Loyalty. Fiduciaries are to act solely for the benefit of current and future beneficiaries. When creating policies or making other decisions, fiduciaries are expected to only wear one hat. That was the earlier reference to representing all members of the WRS, not any specific subgroup or any association to which you may be a member. Loyalty. There is no fiduciary duty owed to the appointing board, no fiduciary duty owed to any subgroup of constituents. However, of course, you should maintain a good working relationship with any of those groups, but remember that your fiduciary duty is owed to the current and future beneficiaries of the fund, and that duty is paramount to all other duties and obligations that you have as a board member. Loyalty to ETF. What we mean by that is, under trust law, you must act solely in the interests of the beneficiaries of the fund. And the duty of loyalty requires that you collect all money owed to the trust fund. It can be, and often is, very difficult to collect overpayments from beneficiaries. But please remember that it is not your job to try to balance the interests of the state with the interests of taxpayers, and it is not your job as a board member to try to please everyone who may want something from the trust fund. Conflicts of interest. The courts are very strict on fiduciaries about this, and as we have seen in recent years, the court of public opinion also is very strict. And it is true that fiduciary standards have increased in complexity over the years. So how do you avoid any conflicts of interest? This slide identifies 4 common methods for trying to do that. Don't engage in any self-dealing. Essentially that means do not act in your own self-interest, but keep your focus on the interests of the members and beneficiaries of the trust fund. Don't engage in self-enrichment. You're not a member of the trust fund board in order to enrich yourself financially. Reputational enhancement, meaning your service on the board is not meant to enhance your reputation, and you should not try to use your status in which to try to accomplish that. Co-fiduciary liability. What we mean by that is quite simply, you are in fact your brother's keeper. If you learn of a violation committed by another board member and you do nothing about it, you are in fact breaching your own fiduciary duty. So how do you protect yourself from liability? Well, this slide that appears before you has several methods that you can try to do that. I'm going to highlight a few. At the top, you see a reference to relying on experts. Not always, but when you feel that there's a need to do so, you should rely on an expert and seek his or her advice. Next, try to seek and obtain advice from certain experts such as attorneys, the counsel to the board, any actuaries, any auditors, or if there's a technological question, try to seek an expert on that technological issue. Another way to protect yourself from liability is to ensure that there is clear documentation of all board actions. And overriding all of those protections is make sure that you are engaging in excellent governance practices and that you are performing oversight activities as set forth in your particular statutory responsibilities. In conclusion, fiduciary standards are very high. When times are difficult, such as over the last few years, boards are in fact closely scrutinized. Be careful, be thorough, and perform scrupulous behavior, and you will be fine in performing your duties. Remember that a first-rate process generally delivers a first-rate outcome. Your members and the beneficiaries of the trust fund expect you to meet and to maintain those fiduciary standards. The remaining slides consist of those statutory responsibilities that pertain to each of the boards that I described or alluded to earlier in this presentation. I encourage you to look at this particular slide that refers to the board on which you serve, but you also should try to become familiar with the other responsibilities pertaining to the other boards that are attached to the WRS. Thank you for your time. I appreciate your service on the boards, and I look forward to working with you. Thank you.